We'll now hear argument in Boyle versus State. Suma.
May it please the Court, my name is Richard Suma. I represent the appellant, Mr. Michael Boyle. I intend to reserve 3 minutes for rebuttal. Mr. Boyle was convicted of the offense of dealing in stolen property. One of the issues that I raised in this case is whether the dealing in stolen property is unconstitutional insofar as it eliminates the mens rea requirement. Now, this argument I derived from the case of Chacon versus State from the Florida Supreme Court, and subsequently, lo and behold, the Florida Supreme Court came up with the case of State v. Rubio, which I submitted as supplemental authority, and which I assert also bolsters our position. And the reason, excuse me, starting with Chacon v. State, there's a portion of that case which cites a very important constitutional rule. The portion of that holding is that a strict liability offense that is subject to felony punishment violates the due process clause of the federal Constitution. I have concluded that the dealing in stolen property offense also eliminates mens rea and should be considered a strict liability offense because of the element know or should know the property was stolen. Given this alternative, the jury, on the face of the statute, may convict the defendant of should have known the property was stolen, which is a strict liability offense or lack of mens rea. As we know from State v. Rubio, the language should know does not constitute mens rea. In the alternative, we've also...
But, counsel, I'm not sure I follow you. How can dealing in stolen property, the statute itself, constitute a strict liability of crime when it requires the state to prove that the defendant knew the property was stolen, or that circumstances were sufficiently suspicious that an ordinary person would be on notice that the property was stolen?
Because the language, the alternative language of should know the property is stolen, essentially imposes a reasonable person standard, instructs the jury that it can decide if a reasonable person would have known that this property was stolen under the circumstances, then you may find this defendant guilty. It doesn't depend on the defendant's actual state of mind or guilty state of mind. Now, in the alternative, we've also argued that in the following issue that we recognize the line of cases that say strict liability offenses are actually not unconstitutional. And we cite the United States Supreme Court case of United States v. Baylant. And this line of cases originated when the legislature started enacting public welfare offenses, or what we also call strict liability crimes, but imposed relatively minor punishment, misdemeanor punishment, no more than a year in prison. So if the court finds that under that argument that it is a strict liability crime, but that's not unconstitutional, then the due process clause of the United States Constitution requires the courts to mitigate the punishment that may be available upon conviction for such a strict liability offense. Another issue which we raise, there are a number of popular misconceptions that need to be debunked in this case. We claim that the jury instruction that possession of recently stolen property gives rise to an inference that the person in possession knew the property was stolen is unconstitutional, and that it's a mandatory conclusive presumption. The popular misconception is that that issue has already been decided adversely to appellant, but it has not. There have been numerous cases dealing with that instruction. They're all summarized in the Florida Supreme Court case of Walker, but none have actually come to resolve that issue. In other words, the Barnes case involved a permissive inference. The State v. Young case involved a verbal.
Can you distinguish this case from Walker, which upheld the constitutionality of the jury instruction at issue?
Yes, Your Honor, on a number of bases. Number one, the jury instruction that was actually given in the Walker case was the burglary instruction, which uses the permissive term may. So any discussion in Walker beyond the burglary instruction is dictum. Moreover, the Walker case considered whether the jury instruction was violative of the Florida constitutional proscription against comment on the weight of the evidence. And that's a different issue than the federal constitutional issue of whether an instruction is an unconstitutional, mandatory, rebuttable presumption, which deals with a shifting of the burden on an element of the offense. And in another case mentioned in Walker, the Edwards case, Edwards considered whether instruction was violative of the defendant's right to remain silent, and another due process claim. Be careful using the word due process because it means a number of different things. In the Edwards case, it meant whether there was a rational connection between the fact proven and the fact presumed. And that's a different type of issue than we have in this case, which is whether the language gives rise to is mandatory in nature and thus operates to shift some burden to the defendant and is unconstitutional as a mandatory rebuttable presumption. There's no Florida case on point. I had to go outside the jurisdiction. I noticed I did cite an Arizona case.
But isn't the Arizona, the Moore case, in direct conflict with Walker?
No, because Walker did not even consider the issue. Because Walker said, we're going to decide whether these instructions are violative of the Florida constitutional right or prescription against comment on the weight of the evidence. That's a different issue than whether an instruction is a mandatory rebuttable presumption which shifts a burden to the defendant. And plus, everything that the Walker said about this instruction was dictum because the instruction that was actually given in Walker was the burglary instruction, which uses the permissive term may. Whether possession of an item stolen in a burglary may give rise to an inference that the person in possession knew the item was stolen. So there are many jury instructions issues here that are very problematic. Another one is the giving of the instruction that sale of property below its market value gives rise to an inference that the person in possession knew the property was stolen. That instruction should not have been given in this case because there was no sale. There was an attempted sale. That instruction is inapplicable on the facts. The rationale for the instruction that is if a person sells an item, that sale is somewhat evidence of dominion and control of the item. But in this case, there was merely evidence of some discussion that, let's talk about price.
Why should we distinguish between an attempted sale and a completed sale for purposes of determining whether the jury should be instructed regarding stolen property at a price substantially below market value?
Because there is not the same rational connection or the inference that may be drawn from sale of the property. When someone sells the property, they're advocating that they have the right to sell it. They have the control of it. They're advocating that they have a possessory inference in it. And they're advocating that it's mine to sell, and therefore an owner has peculiar knowledge about property. So the jury may then infer that the person also had knowledge that it was stolen. But on these facts, where you have an attempted sale, the defendant may have simply been fielding offers for his friend. The court will remember that it was an unknown third party, simply described as a white male, who brought this property into a pawn shop and attempted to sell it. When the pawn shop was not interested, this unidentified third party took it out of the pawn shop, brought it to the truck, and there's a disputed fact as to who loaded it into the truck, But then there's some evidence that the defendant then said to another party, would you want to buy this? How much? Et cetera, et cetera, et cetera. But on those facts, you don't have the same rational connection that the defendant knew about.
But didn't the defendant exercise sufficient dominion and control over the stolen property when he offered to sell it to the other individual?
No, because it was only an attempted sale. We don't know. We don't know if the person had said, yeah, I'll buy it for $250. We don't know if the appellant would have said, okay, it's yours, here, take it, give me the money, or he would have said, hey, Joe, this guy's offering you $250 for the property. You want to make a deal with him? See, that's the difference between an attempted sale and a sale. The decision to actually consummate the sale may not have rested with the appellant.
But certainly the fact that the appellant was offering the item for sale is evidence of his dominion over the item. It may not be as definitive as if it had sold. A reasonable person may consider that some evidence of dominion and control, but we don't know, and we don't have the right to judge that the standard instruction was designed for that purpose, because the standard instruction says a sale gives rise to the inference because it's evidence of dominion and control. But what I'm arguing is that attempted sale is not as strong as an inference. And absent an express direction that this instruction applies to attempted sale, it should not have been given. That means it's an error as to a disputed element of the case. Clearly, knowledge was the disputed element. And therefore, of course, we have a number of similar issues. We claim they're fundamental error because they're jury instruction issues. They all deal with the disputed element of the offense. And none of these were objected to, so hence your fundamental error argument.
None were objected to, but they're all erroneous instructions on disputed elements of the offense and may be considered for their cumulative effect as well. I thank you. I'm into my rebuttal time.
Good morning, Your Honors. Please, the Court. Charlie McCoy on behalf of the State. Your Honor, as best I can, I'll try to track the issues in the same order that opposing counsel did. So turning to the facial constitutionality of the stolen property statute, there a critical premise is that on its face it imposes strict liability because it's eliminated mens rea. Absolutely wrong. Couldn't be more wrong. The statute says the State has to prove knowledge. It gives the State two ways to prove it, either actual knowledge because they prove the defendant did know the property was stolen, or because the circumstances are so compelling he had to have known the property was stolen. And you can call that either constructive or imputed knowledge, but nevertheless, the State still has to prove knowledge.
Then, counsel, how was there an appropriate factual basis for giving the jury instruction regarding possession of recently stolen property for the appellant when the goods that were found in another person's vehicle, and the appellant was not the person who attempted to sell them in the pawn shop?
But he was the person who attempted to sell them out on the street by offering them for first $300, then $250, then $200. And since you're talking about dominion and control, I'd like to respond to a question that you posed. You said, couldn't the jury infer dominion and control? And of course, counsel's response was it was an attempted sale, and it wasn't completed, which of course is factually correct. But Mr. Boyle did everything he could possibly do to effectuate that sale. He lowered the price twice when an honest citizen got suspicious or was wary for one reason or another and declined to buy the property. So through a pure fluke that he had an honest citizen not wanting to acquire a property that maybe the citizen didn't know was stolen or not, but at least was wary of it or whatever reason, just a pure fluke of what the citizen did in response to the offer, he tries to say that he didn't have dominion and control over the property. He certainly conveyed that impression to the person he wanted to sell the property to. So that argument of the incomplete sale is wrong on that point. Now, since it's closely related, as far as going to the jury instruction, which does literally anticipate a completed sale, and what you're actually talking about is the jury instruction on the inference that It's the second inference in the instruction. Proof of purchase or sale of property substantially below the fair market value. 2 points there. First off, it would make no sense at all to allow someone to be convicted for endeavoring to sell stolen property, which is actually obviously what that statute he was charged under allows, as well as actual sale, and then the jury not be able to draw the same inference through a clearly attempted sale when the defendant did everything he could to finish the sale, if you will, and not draw the same inference. It would be an absurd result, and certainly if the state had requested a special instruction, just say proof of a sale that was attempted but not completed through no action of the defendant. It was only, like I say, the honesty of the citizen that the sale didn't go through. The state could have gotten a special instruction. That's certainly not fundamental error, Your Honor, to have given the instruction. And remember, we're talking about error that has to be rare. It has to vitiate the fairness of the entire trial. And I want to emphasize that when the U.S. Supreme Court upheld inferences in that Barnes decision, which was relied on heavily, and I think it was in the Walker case, they said that inference satisfies due process when two things happen. One, the state's required to prove the underlying facts beyond reasonable doubt, which is, there was competent substantial evidence adduced here from which the jury did find had no reasonable doubt as to the dealing in stolen property charge. And it's grounded in common experience. And, of course, they were talking there about if you're the person that's, for centuries, the common law had recognized that if you're the person who's in possession of recently stolen property and you have no satisfactory explanation, then there's a very high probability that you were the one who took it. And that's why they said those kinds of inferences don't violate due process. Well, that's exactly what you have here. Now, I want to emphasize that this, going to the issue of the facial...
But counsel, I'm not sure I follow you. Why can we have this inference, why it's permissible to give this inference of selling recently stolen property when there's no evidence to this record that the defendant actually sold the property?
I couldn't quite understand the first part of your question.
In regards to issue number 4,
all right,
where it was a trial court instructed the jury on the inference of knowledge of guilt based on selling the property at a price substantially below the market value. In this case, there was no evidence that the defendant actually sold the property, so why should this inference be permissible?
If they had objected on that ground, we might have had reversible error. They're having to show fundamental error here, Your Honor, is the first thing I want to... Secondly, it would be an absurd result if somebody can be convicted for endeavoring to sell, yet you show they endeavored to sell, and you can't draw an inference that they knew the property was stolen. It's an absurd result as well. Again, their obligation here is to show fundamental error and not mere reversible error. And given that the facts were well proven to the jury's satisfaction, there isn't any due process problem that would rise to fundamental error here.
Mr. McCoy, going back to the constitutional challenge to the dealing in stolen property.
Yes, sir.
Statute. How is this statute materially different from the statute that was involved in Rubio?
Well, Your Honor, the Rubio case involves several statutes. First off,
I'm talking about the one, though, where they rely on the done by a person who is aware or should be aware of, as opposed to this statute, which uses knew or should have known.
Well, first off, Your Honor, I think that's the false claims statute that they were addressing in that context.
That's the first one they dealt with.
Well, a false claim has attributes of fraud, which is a specific intent statute. And to show falsehood of the claim, is not along two reasons. First off, it at least smacks of a specific intent statute, and it's well established that theft here is a general intent statute. And the long-held, if you will, common law even premise that if you're the last one in possession of stolen property, recently stolen property without an explanation, is grounded in centuries of experience. That doesn't arise here. I would hasten to point out that Rubio also upheld the patient brokering statute despite its absolute lack of a mens rea.
Right.
So,
yeah, I understand that, but coming back here, I mean, if you just look at the text of these statutes, though,
right.
they're very, very much alike, aren't they?
Yeah. Yes, Your Honor, and I would point out that when the Florida Supreme Court considered the burglary statute and the burglary instruction in Walker, one of the earliest things it said in the opinion was that it was quite similar, was their actual language to the instruction in the theft statute, and they never again bothered to distinguish between the two. And the burglary statute, Mr. Boyle is arguing that it's acceptable because it uses the word may. I would hasten to point out that the burglary instruction, while it does say may, what comes immediately after that word? It says may justify a conviction for burglary. To me, that's a lot stronger language than gives rise to an inference. So I think that if the burglary instruction on an inference may justify a conviction of burglary is acceptable, then so is the lesser or less strong language of gives rise to an inference. Secondly, if the Walker statute is what they say about the theft statute is dicta, it's well established that dicta of the Florida Supreme Court interpreting these matters of state law can be considered highly persuasive. Now, the fact that they were considering a different aspect of due process, and this is why I think people find the Walker decision controlling here, and why the state's argument is controlling. Yes, it was a different aspect of due process, but what was the due process claim in Walker? Well, as a comment on the evidence, it did one of two things. It either shifted the burden of proof or deprived the jury of its fact-finding role. Well, here's what they're basically saying the same thing here, that if it's a mandatory presumption, which of course the state disagrees, the instructions creates a mandatory presumption at all, then that deprives the jury of its fact-finding role. So the rationale of Walker is so strong and so analogous in that sense that it's very highly persuasive, and certainly this court has to follow it and can't just reject it out of hand in favor of an intermediate decision from an Arizona appellate court, which is what Moore is. Looking at the face of the jury instruction as well as on the inference, I want to point out to this court that gives rise to an inference is not the only critical language. That instruction also has on its face proof of possession of stolen property unless satisfactorily explained. So on its face, it acknowledges the opportunity of the defendant, if the defendant chooses, to satisfactorily explain something. And as the U.S. Supreme Court said in the Barnes decision, which is relied on heavily in Walker, that doesn't shift the burden of proof. That shifts only the burden of going forward with the evidence. So that satisfactory explanation language is tantamount to an affirmative defense. The defendant, it doesn't shift the burden of proof away from the state, but it gives in the context of your stolen property, it gives the defendant the opportunity to explain why he or she had recently stolen property. So again, the inference, there's nothing in this language that says, jurors, you have to draw this inference. It does, certainly nothing there that says you have to convict. There's certainly nothing in here that says may justify a conviction like says in the burglary instruction. So I think the critical premise for their entire argument as to the statute and the jury instruction together, for that matter, is that it does create strict liability. It does not. And it doesn't eliminate mens rea. It gives the state two ways to prove knowledge, and there's nothing wrong with that from a due process standpoint. And again, I would emphasize that all their objections to these problems they have with the jury instruction have to do with a fundamental error and not reversible error, and they haven't shown that giving any of these instructions was so unfair that it vitiated the entire trial. For example, the fair market value complaint. Well, the victim said, hey, we bought them 4 weeks earlier, we paid $1,100 for the speakers and the amp, and the facts were that Mr. Boyle offered to sell them for as low as $200 just 4 weeks after they were purchased. In fact, the state's main witness, that Kreppel, however his name is pronounced, said that one thing that attracted his attention was they looked like a new model to him. I've lost track of the different issues that were addressed, but did address the second issue. That's the jury issue. The sixth issue was facing national constitutional statute. The fourth issue. Your Honors, if I could sum up then, the single most important point as to the facial constitutionality of the statute, and for that matter the jury instruction, is that this gives rise to an inference language by itself does not require the jury to make the inference. It doesn't require them to convict if they do make the inference. It doesn't shift the burden of proof or take away the jury's fact-finding function. It's not even as strong an instruction as the burglary instruction, which was upheld, I agree, against a different due process attack, but one that was very similar because it involved either shifting the burden of proof or depriving the jury of its fact-finding function. And the dominion and control we've already addressed. I want to emphasize in closing, of course, that on its face, the statute, stolen property statute and the instructions allow the state to prove knowledge two ways. Mens rea is not eliminated. And then finally, the state can impose strict liability for criminal statutes that impose serious penalties and has done so in the past and currently in several instances. I guess the most striking example, of course, which I'm sure y'all would occur to you, would be sexual battery, in which if the victim is young enough and the perpetrator is old enough, not only is consent eliminated as a defense, but if you look at 794.021, I think, has eliminated deliberate misrepresentation of age by the victim as a defense. And never been a problem with that. It's been changed by the legislature as a matter of policy since, but the original DUI manslaughter didn't have a causation element. And a case arose where, and that didn't cause a constitutional problem. So this, again, there's no strict liability here. The state can prove knowledge two different ways. Any of the other errors they've complained of, maybe they would have been reversible if an objection had been made. Certainly if there had been an objection to the statute, the instruction on attempted versus completed sale, would have given the court and the parties an easy opportunity to correct it. At least there would have been a ruling. And so you need to affirm the ruling below, because none of their arguments about preserved error are correct, and none of their arguments about the other errors show error so egregious as to be fundamental. Thank you.
Thank you. With respect to the penalties that are available for strict liability offenses, we discussed in our briefs that the circumstance of sexual battery or sexual crimes against a minor is exception to this rule because of its common law antecedent. That's well recognized. But this type of statute is not an exception of the rule because it doesn't have the same common law antecedent in history. With respect to the DUI statute, DUI manslaughter or DUI, that's frequently cited as an example of a felony offense for a strict liability of crime. That's a very popular misconception because DUI manslaughter is not a strict liability crime, which the Florida Supreme Court said in State v. Baker. The language is, DUI manslaughter is not the classic strict liability crime. Even under the model penal code, which is very critical of strict criminal liability, the act of operating a motor vehicle while intoxicated involves culpability. We are not dealing with the type of statute which imposes strict criminal liability for mere negligence or even an act malum prohibitum. The operation of a motor vehicle while intoxicated is a reckless and therefore culpable act. So the basis or the premise for imposing strict felony punishment for DUI manslaughter is the recklessness, which is a form of mens rea. It's recognized as the least culpable form of mens rea, but is a form of mens rea because of the critical distinction between negligence and recklessness. Negligence occurs when a person is not aware of the risk of danger and may act carelessly. In a civil context, a jury may find recklessness. That's a lack of awareness of danger. Recklessness is an awareness of a danger, a risk of danger, but ignoring that danger and consciously electing to proceed with your actions. That's the stated distinction between negligence and recklessness. Recklessness is a form of mens rea, although less culpable than strict liability, less culpable even than, less culpable than strict intent, specific intent, I'm mixing my terms, and even less culpable than general intent, which is also a form of mens rea. And then further one step down the ladder is recklessness. So the offenses, the drug offenses and the dealing in stolen property offenses do not have a common law history, and therefore they may be punished as strict liability offenses, but not felony punishment. Thank you. My time's up.
Thank you, Mr. Senator. Thank you both.